Now friends, ladies and gentlemen, I propose to take accounts under the Companies Act 2013. The provisions in regard to accounts are given in chapter 9 of the new act. What we have to talk about in this chapter of accounts? We have to talk about what do you understand by the accounting standards? What do you understand by the financial statement? How the financial statements are prepared? Where they are kept? Where the financial statements are to be kept? And as we know, that a new concept in the topic of accounts has been introduced, which is popularly known as corporate social responsibility, CSR. We'll talk about the CSR as well. Then we'll talk about whether the members are entitled to the financial statement. The financial statement are to be filed with the registrar, and the new concept of the internal audit. So these are the topics that we have to talk about. And they are from section 128 to 138. But remember here, 3 sections have not become operational. And they are section 120, 130, 131 and 132. So therefore these are the 3 sections that we will not talk about. Now let us take the accounts under the new Companies Act 2013. Now friends, basically the things have remained the same as they were before. 2 things have been done under the new act. One is that the amount of penalty for the contravention of any provision has been enhanced, has been increased. We may say manifold, the amount of the penalty has been increased. And as and when there is ambiguity, by way of new act, we have tried to remove the ambiguity, the vagueness. We have tried to remove them. And thirdly, we have made the provision little wider. So therefore, with these 3 objectives in view, we have announced the penalty, we have wider the concept or the things proposed, and we have tried to remove the ambiguity. Now to begin with, section 128. 128 is almost similar to 209 of the old act. Now what section 128 has to say? 128 says that every company, maybe the public or the private, has to prepare and keep books of accounts and the other relevant documents and the financial statement of the financial year. So therefore every company has to prepare and keep the books of accounts, the financial statement of the year, the relevant documents and the papers, and they are to keep, every company, at the register office of the company. Now what these statements show? These statements, when we prepare and we lay, and when we prepare and keep at the register office of the company, then the basic object of these documents are to show the true and fair view of the state affairs of the company. And in case the company has the branch, to show the true and fair view of the state affairs of the branch as well. And these documents are to be prepared as per double entry system and on the accrual basis. Then further the law says, can the company keeps these documents at some other place other than the register office? Because to begin with, we have to keep at the register office of the company. But can we keep these documents at some other place other than the register office? We are willing to keep at some other place. We don't have the sufficient space at the register office. Can we keep at some other place other than the register office? Yes. If the decision is taken by the board and board decides to keep these documents at some other place in India other than the register office, if they want to keep at some other place in India other than the register office, then they can keep at other place in India. But then they will have to do one thing. What they will have to do? They will have to deliver the address to the registrar within 7 days of their decision, that this is the address where we are keeping the books of accounts and the other relevant documents. Then further the law says, suppose you have a branch in India or you have a branch outside India. Now remember here, what we are talking about right at the moment. We are talking about where we can keep them, either at the register office or some other place in India, if the board has decided, provided the intimation of the full address has been given to the registrar within 7 days. And number third, we can keep the books of accounts. Then the third, if suppose we have a branch, the company has a branch. You may have the branch in India or you may have the branch outside India. Then a little exception has been provided. And what is that exception? That all the books of accounts relating to the transactions effected at the branch can be kept at the branch office. So you have a branch in India, you have a branch outside India. The transactions have been effected at the branch. All the books of accounts in regard to the transactions you can keep at the branch in India or outside India. But then if you keep at the branch in India or outside India, then you have to do one more thing as well. You can keep at branch in India or outside India. But then the summarized return about these documents will have to be sent to the company at the register office of the company or at some other place in India periodically. So this is the place where you have to keep register office, some other place, books of accounts at the branch. Then further the law says, can we keep the books of account in electronic form? Because the things are changing. What we did not think before, we are forced to think today. Because the things are moving very fast. So can we keep the record in the electronic form? The law says yes. We can keep the record in the electronic form in such manner as may be prescribed. This is one part of the law where you have to keep. Then further, can the books of accounts and other relevant documents be inspected? Because when you keep, they are also liable to be inspected by someone. So 128 further says that these documents, the books of accounts and the other relevant documents that we are keeping, they are open for inspection. Inspection by whom? Inspection by the director. When? During the business hours. So they are open for inspection by the director during the business hours at the register office of the company or at some other place in India. They are open for inspection. Then further, once they are open for inspection, then provide the facilities for the inspection. Otherwise, the right of inspection becomes meaningless. I have a right to inspection, but you don't provide the facility. So my right is no right to me. So therefore the law says, if the facilities of inspection are provided, then it becomes the duty of the officers and the employees of the company to give all the assistance for the inspection which the company is reasonably able to give. So this is inspection about. So therefore you have to keep, and they are open for inspection by the director during the business hours. Then further, when you have to keep the books of accounts and the other connected related documents. Then how long you are to keep? Are you keep for all the time to come? Are you keep for many, many years? There ought to be some limit for the time for which you have to keep these documents in the good order. Then the law further says that these books of accounts and other connected vouchers will be kept in good order during the preceding 8 financial year. See the beauty of the law. So you have to keep for the 8 preceding financial year, which means if suppose we are deciding today that today we have to destroy them, then naturally we must ensure that before we decide to destroy these documents, whether 8 preceding financial year have gone by. So therefore the law says that the books of accounts and other related documents will be kept in good order during the last 8 preceding financial year. And then in this financial year, then you can decide to destroy them. But then the other question is, as we have been talking about, that the law should be complete. Then the other thing is, if suppose the company has not been in existence for 8 financial years, if the company has not been in existence for 8 financial year, then you will keep the books of accounts. Then you will keep the books of accounts during the preceding financial year during which the company has been in existence. Suppose the company has been in existence for 7 years. Now remember here, 8 years is the minimum period. So therefore the company has to keep the books of accounts for at least 8 preceding years, 8 preceding financial year. Then the financial year in which you are deciding to destroy. So you have to keep for at least 8 years, preceding financial year. But if suppose the company has not been in existence for 8 financial year, then you have to keep the records for the period preceding financial year during which you have been in existence. So this is the period for which you have to keep the record. Then there is another provision in the law. Suppose on the basis of these documents, investigation has been altered. Then the government may prescribe that you have to keep these records for the longer duration, which the government thinks proper. So therefore, and this is the period for which you have to keep the record. Then how much is the penalty? As I talked about before, then in the new act we have increased the amount of the penalty manifold. So what is the amount of the penalty? So therefore the law provides, section 128 provides that there is a contravention. Then who is liable for the contravention of any of the requirement of this section? Which means you have destroyed before 8 years, you have not kept properly, you have not allowed the inspection. So these are the things for which the contravention has taken place. Or you keep the record, but they do not show true and fair view. So what is the utility of the record keeping? So when we say there is a contravention of what? Contravention of any of the requirements of this section. Now what are the requirements of this section? That you have to keep at the registry office. They must show the true and fair view. You must allow for inspection. Reasonable facility should be given. They must be kept in good order for a particular period. So these are the requirements of this section. If any of the requirements of this section is not complied, then who is liable and how much liable? 2 things. Who is liable and for how much you are liable? Who is liable? Managing director. The whole-time director in charge of the finance. The chief executive officer. The chief financial officer. And any person who is charged by the board with the responsibility of complying with this section. So these are the people who are liable if any of the requirements of this section is not complied. Who are these people? Maybe the managing director, maybe the whole-time director in charge of finance, maybe the chief executive officer, maybe the chief financial officer, or maybe any other person charged by the board with the responsibility of complying of this section. So these are the people liable for the contravention. Then the question is how much liable? For how much they are liable? Their penalty is very, very heavy. the penalty is much greater. They are liable for imprisonment which can go up to 1 year, or with fine which will not be less than 50,000 rupees, but which can go up to 5 lakhs of rupees. Now remember here, the law has not provided the penalty can go up to 5 lakhs of rupees. Because once the law provides that the penalty can go up to 5 lakhs of rupees, which means that the penalty can be from rupee 1 to 5 lakhs of rupees. But the new act has not said that. New act has said that the minimum penalty will not be less than 50,000, which can go up to 5 lakhs. So we have increased the amount of the penalty.